Thank you for joining us. I'm Dan Sutherland and I head up the professional services team here at Fox Williams. I'm joined here today by my colleagues Tom Custance and Ed Livingston. Tom is a partner in our litigation team and also our CULP. Ed is a legal director in the professional services group. So today we wanted to talk about an aspect of the Economic Crime and Corporate Transparency Act that recently came into force, and that is the new criminal offence of a failure to prevent fraud. And we want to talk about how that might affect professional services businesses and law firms in particular. So Ed, what can you tell us about the new offence?
Thanks, Dan. So the new offence came into force on 1st of September. It's often called the duty to prevent fraud, although that's not strictly accurate in that it's an offence of failure to prevent fraud, although it's probably wise for law firms and other professional services business to consider it a positive duty. It's designed to ensure firms sort of proactively stamp out fraud and don't turn a blind eye to fraudulent practices which are to their benefit. So to talk about exactly what the legislation says about the offence, it's committed where an employee, subsidiary or an agent of an organisation commits what's called a fraud offence. That can be any number of economic crimes, including false representation, cheating the public revenue, fraudulent trading, false accounting, and so on. And it does so with the intention of benefiting the organisation, including its parent entities or in some cases its clients. It doesn't actually apply where the organisation itself is the victim of the fraud. So it's a strict liability offence in that senior management of the firm doesn't need to be aware of the underlying fraud offence. The organisation can be liable under the legislation even if the person committing the actual fraud offence was relatively junior. The only way you can escape liability and criminal prosecution is to establish a defence of what's known as having reasonable fraud prevention procedures, or in some cases that it wasn't reasonable to have any, although that's unlikely to apply in practically all cases. So essentially that's where the importance of having proper policies and risk assessments and so on and other fraud prevention measures in the business comes in. So now is the right time for firms to assess what they have in terms of prevention procedures and whether they need to be reinforced.
Thanks, Ed. So my understanding is that this offence is potentially somewhat more limited in scope than all firms. But is it something that all firms nonetheless need to be concerned about?
I would say so, certainly in sort of regulated areas of business such as law firms. Strictly speaking, the crime, it can only be committed by what's called a large organisation, which is ascertained by tests relating to turnover or balance sheet total or number of employees. So they have to meet 2 out of 3 of those tests before they're actually in scope of the offence. So small firms under those thresholds would not be caught and therefore not liable to be prosecuted. But obviously for law firms, and Tom will come on to why this is, but for law firms it would be wise for all of them to essentially act as though it does apply and therefore that they use this opportunity to review their fraud prevention measures and how they might be strengthened.
So I think a lot of professional services businesses and law firms in particular might struggle to understand how it is they might commit this offence and really where the circumstances are that this kind of fraud might take place, particularly say in a law firm. Can you give some examples?
Yeah, I mean obviously there's any number of ways in which fraud can be committed in the context of a legal practice. I mean, perhaps most obviously might be making false representations to clients, for example, in a overcharged bill with sort of padded time entries. That's obviously one that you do see in the legal press every now and then. Could be the diversion of client money in the client account, either to the firm or to another client potentially. There's also the prospect of a firm being involved in misleading the court or the counterparty or the client in the course of litigation. So any number of ways. So every firm needs to sort of think about its own business and ensure that it's sort of properly risk assessed and spot the vulnerabilities it has and make sure they can plug all the gaps.
And so how practically would you suggest firms address that risk assessment?
Yeah, so I think the starting point is the risk assessment process. It would be quite similar to what regulated sector firms do under the AML regulations, where you have to have a practice-wide risk assessment. But obviously the focus is on the potential areas for fraud, such as the ones we've just discussed. Obviously the client account is a key thing, but it's not the only thing to think about. So once you've done that risk assessment, that's going to inform your sort of policies and protocols and controls to prevent the sort of fraud risks identified. Something like processes for authorizing payments. You might want sort of 2 signatures on certain types of payment out of the client account and so on. You might want sort of a written practice around use of other people's signatures. So an assistant might, with their partner's authority, use their signature, but there needs to be controls around that so it's not misused, for example. And then obviously once all of those sort of procedures are essentially put in place, they need to be properly recorded in written policies tailored to the findings of the risk assessment. And then thirdly, I'd suggest you'd want to do due diligence measures on sort of new contractual relationships that you might have. For example, taking on new employees, new suppliers, new partners, background checks and so on, as part of reducing the risk. Fourthly, you'd want to think about, sort of related to that, having the right contractual obligations in place for your suppliers in your LLP agreement, in your employment contract. So, for example, you might have a specific ground for terminating the relationship in the case of fraud, and also specific obligations to be vigilant against fraud risks. And then fifthly, another key area for firms to think about in terms of how to comply is to ensure that staff are properly trained and educated so that they sort of know how to spot the red flags of fraud and combat it, and how and where to report it, ensure there's a clear sort of whistleblowing reporting channel so that any potential fraud risks are identified sort of within the organisation and can be combated.
Thank you, Ed. So, Tom, so I think for most firms, they're probably more worried about the regulatory angle to this, because the SRA has been a very active regulator, and a prosecution under this is, perhaps a much less likely scenario than, say, a regulatory breach arising from the same kind of set of facts that could amount to the offence. So, in terms of the sort of regulatory obligations, how does this offence kind of interact with those?
Well, there's actually a direct link between the offence and the existing SRA Code of Conduct for firms. So in paragraph 2 of the Code of Conduct, which deals with compliance and business systems, so paragraph 2.1a says that you have to have effective governance structures, arrangements, systems and controls in place to ensure not only that you're complying with the SRA's regulatory obligations, but also any other regulatory or legislative requirements which apply to you. So if you are a large organisation as a firm, so you satisfy 2 of those 3 thresholds, more than 250 employees, more than 36 million in turnover, or more than 18 million in assets, and you haven't got reasonable fraud prevention measures in place, that means not only are you facing penalties for breach of this new criminal offence, but you're also facing penalties for breaching the existing Code of Conduct. If you're not a large organisation, I don't think you can take a back seat on this. I think probably the key principle here is principle 2, which requires that you act in a way that upholds public trust and confidence in the solicitor's profession and legal services provided by your solicitors. So you can see a situation in which, if as a firm you don't have reasonable fraud prevention measures in place, such that one of your employees or partners can commit a fraud which benefits the firm or a client, that would amount to a breach of principle 2. And clearly, if as a firm you're complicit in a fraud, so if, for example, you have you encourage overcharging of clients, or at least turn a blind eye to it, that clearly puts you straight into the territory of breaching principles 4 and 5, honesty and integrity.
And so Ed was talking then about the scope of the offence being limited to the larger firms, mentioned that all firms probably need to pay heed to it. Yeah. Clearly the SRA Code of Conduct applies to firms of any size. Indeed. So is this something that all law firms need to consider?
I think definitely. And I think, Ed's touched on some of this. I think it's a question of looking at your existing risk assessments, procedures, policies and controls, but looking at it for a slightly different lens now in light of this new offence. So you might classically think of employee fraud as an employee seeking to benefit themselves, in which case, and not the firm or a client. So that's not engaging the offence. Or money laundering would typically be a client using the firm to benefit itself with no intentional involvement from somebody within the firm. So again, the offence is not engaged. So now you're thinking through in what situations could an employee or partner or anybody else on behalf of the firm do something fraudulent which benefits the firm or a client. So if a partner routinely overcharges clients, their primary motivation for doing that may be to improve their own figures so they get a bigger bonus or profit share, but it's also, of course, benefiting the firm. Or if an employee assists a client to commit a fraud, again, the primary motivation may be to ingratiate themselves with the client in the hope of more instructions, more fees, but of course it's also benefiting the client and probably the firm. So it's thinking through those sorts of scenarios and looking at your existing policies and procedures. And the key thing, as Ed was touching on, is demonstrating that you've thought about this and documenting it, because that's going to be your defence, that you have actually put in place reasonable fraud prevention measures, so far as practicable, to mitigate against these sorts of risks.
Thank you, Tom, and thank you, Ed. And thank you for joining us. We hope that was a helpful explanation of the new failure to prevent fraud offence, and we hope you join us for more Professional Services Group bite-size videos. Thank you.